Hello, I'm A.G. Harmon, Associate Dean of Bench and Bar Programs here at the Catholic University of America's Columbus School of Law. Welcome to the second annual Seigenthaler debate, one of Catholic law's First Amendment initiatives. The purpose of the initiatives is to provide a collegial forum that fosters debate, dialogue, and study of First Amendment issues from all sides. Catholic law is proud to be a leader in this area of legal education and hosts this program along with the Seigenthaler Sutherland Cup First Amendment Moot Court Competition, now in its 74th year, and the oldest moot court competition of its kind in the nation, the Judicial Clerkship Opinion Writing Conference, and the Center for Religious Liberty. The debate is co-sponsored by the American Enterprise Institute and our school's chapters of the Federalist Society and the Democratic Law Students Association. We thank them all. The Seigenthaler debates features two First Amendment scholars engaging in free speech issue that is to be argued during the upcoming Seigenthaler Sutherland Cup competition. The debates are named after John L. Seigenthaler, journalist, publisher, and free speech advocate. The 2023 program is conducted in honor of the late Judge Lawrence Silberman of the United States Court of Appeals for the District of Columbia. The resolution that is the subject of this year's debate is resolved. The legal regime for defamation inaugurated by the New York Times versus Sullivan is too protective of free speech over reputation. Each position, pro and con, begins with an opening statement on the topic, followed by questions from our moderator. Taking the pro position is President Rodney Smolla of Vermont University's Law School. Prior to his current role, President Smolla was president of Furman University and dean at Washington Lee University and the University of Richmond Law Schools. He has been a faculty member at William & Mary, DePaul, the University of Illinois, and the University of Arkansas Law Schools, and a visiting professor at law schools of the law schools of Duke, the University of Georgia, and the University of Indiana, the Denver University, and the University of Melbourne. Additionally, he has served as the director of the Institute of Bill of Rights. Institute of Bill of Rights Law at the College of William & Mary, and senior fellow and project director of the Washington Annenberg program of Northwestern University. He currently serves as the chair of the AALS Committee on Academic Freedom and Tenure. President Smolla has been and remains an active litigator, and particularly well known for his representation of American and international clients on matters relating to defamation and invasion of privacy. Has published more than 100 articles in law reviews and other publications, and numerous treatises and texts. Taking the con position in our debate is George Freeman, executive director of the Media Law Resource Center, a nonprofit trade association supporting the media in legal matters. Before that time, he was of counsel to the law firm of Jenner and Block. For 31 years, he was chief First Amendment lawyer in the legal department of the New York Times, leaving as vice president and assistant general counsel in 2012. At the Times, he was primarily responsible for newsroom counseling of the Times, the company's many other newspapers and its television stations and magazines, and also responsible for the newspapers and company's litigations, was at the forefront of numerous high-profile First Amendment cases. He was the William J. Brennan Visiting Professor at the Columbia Journalism School, and also for decades taught at New York University's and CUNY's Graduate School of Journalism. He has been chair of the ABA's and NYS Bar Association's media law committees, and was the co-founder and longtime co-chair of the ABA's Forum on Communications Law annual conference. Moderating the debate is Judge Tom B. Griffith, special counsel to Hunton Andrews Kurth, and emeritus federal judge in the United States Court of Appeals for the District of Columbia Circuit, serving from 2005 to 2020. The Washington Post has described him as widely respected by people on both parties and a sober lawyer with an open mind. Judge Griffith began his legal career in private practice before serving for 4 years as Senate legal counsel, the nonpartisan chief legal counsel of the United States Senate. And in this capacity, he represented the interests of the Senate in litigation, as well as advising Senate leadership and committees on investigations. After a brief return to private practice, Judge Griffith served for 5 years as general counsel at Brigham Young University. At this point, I'm going to turn the floor over to President Smolla, who will begin the exchange with his opening statement on our resolution about the scope and impact of New York Times versus Sullivan standard on reputational rights. After he finishes, we will hear George Freeman's opening statement. So, President Smolla, if you will begin.
Thank you, Professor Harmon. And for those of you that will watch this recording, you may think it's somewhat magical that when you watch me and my friend George Freeman, you will have different suits and ties on during the question and answer period than you're seeing us wearing at this moment. And that's because this is a do-over. We had a technical glitch, and George's opening and my opening didn't come through on the original recording. And so we're doing this. We've already been asked and gone through the debate with the excellent questions of Judge Griffith. And so we are giving our opening statements having already closed, if you will. So I'm going to repeat the things I said when we had this live, and I'll look forward to hearing from George as well. I want to begin by saying it was a real pleasure to have Judge Griffith as our interlocutor. As you will hear, he asked us terrific questions, very pointed questions. And I'm going to keep my opening relatively short because you'll hear a lot of the themes that I talk about and George talks about repeated in a lot greater depth when we get to the question and answer period. It's an honor to be doing this program in honor of the late Judge Silberman. And I'll explain why that's particularly poignant and important for me in just a minute as I talk about a case that I argued in front of him dealing with the very topic that we're dealing with today. I'll also mention what I said in the live debates, which is that George Freeman and I have had a lot of interactions professionally over the years, and sometimes as allies on the same side of matters and sometimes as opposing counsel on matters, but it's always been a most collegial and friendly and professional relationship, and it's a delight to be on this program with him. So I have had 3 cases in Judge Griffith's court in which I was the principal appellate lawyer and argued the case. And I bring them up because they all happen to be in the District of Columbia Circuit. In all 3 cases, actual malice was a pivotal issue. And in all 3 cases, the plaintiff, whom I represented, lost because of the actual malice issue. Judge Griffith was not on any of these panels. I never had the honor of having him, but other members of his court were. And I want to very, very briefly describe the cases because I think they set up some of the critique of New York Times v. Sullivan that you're going to hear George and I debating throughout the rest of this program. The first was a case called Lawrence versus Donnelly. And in this case, I represented Carrie Lawrence, who was one of the first female pilots to fly in combat in the United States. She was pilloried by people who did not want women fighting in combat, didn't want women in combat roles on jets flying off of our aircraft carriers. And she was defamed by falsehoods about her abilities as a pilot. She was an excellent pilot, but because there were folks that had a grudge against women in the military, they selectively and disingenuously presented her record in a way that made her look like she wasn't a good pilot. She was deemed to be a public figure, even though she herself never sought publicity and once said the plane doesn't know the gender of the person flying it. Because she was a pioneer, because she was sort of like Jackie Robinson breaking the color barrier in baseball, she was deemed to be a public figure. The panel opinion in that case, I should mention, included John Roberts, who would later, not long after that decision, become, of course, the Chief Justice of the United States. Once that happened, then the burden, of course, was on us to demonstrate actual malice, and we lost the case on a motion for summary judgment with both the district court and the appellate court ruling we didn't have enough evidence to go to a jury on actual malice. I fought hard against that, but lost. Then in a second case in the DC Circuit, a case called Jankovic versus International Crisis Group, I represented a prominent person, a prominent business person from Europe named Philip Zepter, who was falsely accused of being a crony of the war criminal Slobodan Milosevic, who was known as the Butcher of the Balkans. In fact, he was not a supporter of Slobodan Milosevic. He worked hard in his native Serbia to try to bring democracy to Serbia. And so he sued, and he was deemed a public figure. And once again, the case ended in a defeat because he couldn't meet the actual malice standard. We worked very hard to say we had enough evidence to go to a jury, but no, the court said there wasn't enough there. And then most recently, and this is where Judge Silberman comes in, I represented two people, Christiana Ta and Randolph McLean, who were officials from their native country, Liberia. They had since moved to the United States. They were falsely accused of complicity in bribes, which did not occur, involving oil matters in Liberia. They brought a suit in the District of Columbia for defamation. They were deemed public officials because when this took place, they had been government officials in Liberia. So, of course, the actual malice standard applied. This was a particularly bitter defeat for me because I felt that they had been wronged and they deserved their day in court. But we were not even able to get past a motion to dismiss. The district court and then the Court of Appeals ruled that we didn't even have enough under federal pleading standards to move into discovery, where I was hopeful we would adduce sufficient evidence of actual malice. In that case, Judge Silberman issued a fiery dissent. It could end up being one of the most famous opinions of his long tenure on that court. And his dissent took up a call from Justice Thomas and Justice Gorsuch, arguing that New York Times should be reconsidered. Justice Thomas, I think, clearly believing it should be overruled. Justice Silberman, in his dissent, channeling many of the themes of Justice Thomas, clearly thought New York Times v. Sullivan and its actual malice standard should be overruled. Justice Gorsuch, I think, is a bit more reserved. His opinion was more on the order of we need to rethink it, maybe overrule it, maybe not. I'm not positive he is, would necessarily believe it should be discarded. As you will hear in the debate that George and I have, I believe that there are sort of three options, three possibilities that one could pursue here in the reconsideration of the actual malice standard emanating from New York Times. The first would be to completely discard the case, a complete overruling of the opinion, saying that the question of what the fault standards should be in American defamation law should be returned to the states as a matter of their own common law or their own state constitutional provisions, but should no longer be constitutionalized at the federal level. That would be the most extreme option. A second intermediate option that you'll hear George and I talk about a great deal would be to retain the actual malice standard in public official cases. So when a government employee sues for defamation on matters germane to that employee's fitness or performance in office, if the person is a public official, they'd still be saddled with the actual malice standard. But under this second option, one could jettison the rule as to public figures. And so for persons that are not in the government, not public officials, they would no longer be subject to the heightened standards that come from the progeny of New York Times v. Sullivan, the Gertz case being the case that cemented the division between public and private figures, and their fault requirements would be returned to the states. And as you'll hear me talk about, the argument for that intermediate step is that there's less power behind the theory of Justice Brennan in New York Times v. Sullivan when it comes to public figures, because his opinion was grounded in notions of seditious libel, of holding the government accountable, the importance of our political discourse, the thoughts of philosophers like Alexander Mecklejohn. And those rationales have less force, arguably almost no force, when the person is not involved in government and the defamation has nothing to do with government. As George will say, there is still the argument that the matters can be very important in our public discourse, but that governmental accountability argument drops out. And then finally, the most modest possibility, which you will also hear us debate, it is actually the argument I made when I tried to get the Supreme Court to look at the Ta case in which Judge Silberman dissented, would be to keep the actual malice standard, but to make some corrections in its application, to make some corrections in the margin in how it is interpreted. And one correction that's particularly pressing in our federal system is the difficulty that any plaintiff faces under the pleading standards of Twombly and Iqbal in pleading enough specificity to get past the motion to dismiss when you are basing a case on the actual malice standard. Because until you have discovery, you don't know. You don't have the text messages. You don't have the email messages. You don't have the first drafts of articles. You don't have all of the things that can often make a solid case that is worthy of going to a jury and is winnable from a plaintiff's perspective. And so that would be one adjustment. A second that you will hear us talk about is, New York Times used this phrase, reckless disregard for truth or falsity. And that is a subjective standard as the law has evolved. The burden is on the plaintiff to demonstrate that the defendant harbored subjective doubt about the truth or falsity of the statement and published anyway without resolving that subjective doubt. But that's not the way we use recklessness in many, many other areas of tort law and criminal law. And to a lot of non-lawyers, an extreme departure from journalistic standards, looking the other way, not bothering to follow leads, they would think that's very possibly reckless conduct. That may not be enough in many defamation cases under the subjective standard. There is this notion that you can show actual malice if you can show someone deliberately looked the other way. That's a very tough thing to prove. I've been in cases where I felt we were able to do that, but it's not easy. So I'm going to end by just very quickly conjuring the rationales for looking at this with fresh eyes, as Justice Thomas and Justice Gorsuch and Judge Silverman have suggested. And I'm just going to talk about two simple rationales, one based on history and the other based on pragmatism. Justice Thomas particularly has argued, in my view, quite forcefully, that you cannot make a plausible case that the framers of the First Amendment had anything like the alteration of the common law of libel in mind when they passed the First Amendment. And the argument for that is they were common law lawyers, they were familiar with the traditional tort law of defamation. They had no sense that what they were doing in passing the First Amendment did anything to displace that. And as I mentioned when we were live, remember, this was the epoch in which people still fought duels, and Alexander Hamilton was killed by Aaron Burr. If anything, the framers would have wanted to have a civilized recourse for reputational injury, not taking it to the streets or to the bluffs outside of the Hudson River. And it does not make historical sense that that's what the framers had in mind. Now, there is a weakness in that argument, and I'm sure George will talk about it. And the weakness is you could say that about most of modern First Amendment law. A lot of it is judge-made law. A lot of it has accreted over time. And you can make the argument it proves too much, because you could say that just about everything that we currently have in modern First Amendment doctrine. But even so, I think the point is well taken. And at best, it should free up our minds. That is to say, in my view, it puts us then in the position where it's fair to ask, what's the best public policy? What's the best balance of the competing interests for this generation as we look at where we are today? And that turns then to pragmatism. There is no doubt that the current regime is an extreme imbalance, and it's been exacerbated by a lot of things like anti-SLAPP laws, the pleading standards I've already mentioned. It is very, very, very daunting if you are a plaintiff to try to win a case under the actual malice standard. And that, I think, is out of balance. It's out of balance. It's not, I bet, what Justice Brennan thought was going to happen and his colleagues thought was going to happen when they authored the New York Times case. I think they got the result right. Almost all the critics of New York Times v. Sullivan think the result was right, but the medicine wasn't the right remedy. The actual malice standard wasn't the right remedy. And it not only damages our ability to get fair recompense for the damage to human dignity and reputation that people suffer, it also damages our public discourse. It allows things like a big lie to go forward without accountability sometimes. I'm on the side of folks that think there should be accountability for that kind of defamation and believe there can be, but it's very, very, very difficult. The odds are stacked so much against the plaintiff. And I think our discourse would benefit, and certainly the protection of individual reputation and human dignity would benefit if in some way we make adjustments to bring better balance, either by discarding the standard or by adjusting its execution. And with that, I'll look forward to hearing from my colleague, George.
Okay, thank you, President Smolla. George Freeman, your opening statement now.
Thank you. Thank you, Professor Harmon. Thank you, Rod, for your kind words. We did this the first time the night after the Super Bowl. And I vaguely recall that I began by saying I felt a little bit like the Kansas City Chiefs, who at halftime were already 10 points behind and barely had the ball. I haven't had the ball at all, but I do feel like I'm 10 points behind, but I'll have you remember that by the final buzzer, the Chiefs won, and I hope the outcome is the same here. I'd start out by just noting that on the official website of the federal judiciary, there resides a link entitled Supreme Court Landmarks, which contains a list and brief descriptions of those decisions that, in the words of the federal judiciary, have shaped American history. And on that list, along with Marbury versus Madison and Brown versus Board of Education, is the U.S. Supreme Court's unanimous 1964 decision in New York Times v. Sullivan. That Sullivan was in this company is not surprising. It got great plaudits as soon as it came out. In the words of Judge Robert Bork, he equated Sullivan and Brown as two premier examples of the court performing its constitutional duty to apply old values to new circumstances. Anthony Lewis, who wrote the definitive work on the Sullivan case, wrote that Sullivan succeeded in laying down the fundamental rules of our national life. It is made clearer than ever that ours is an open society whose citizens may say what they wish about those who govern them. I particularly like what's really has become a famous statement of Alexander Meiklejohn, who was a First Amendment scholar and also happened to be the president of Amherst College, where I happened to go to school. And he said it was an occasion for dancing in the streets, the Supreme Court decision in Sullivan. And finally, there was a South African attorney, Albie Sachs, who became a judge in the post-apartheid era in South Africa, and said the ruling shone like lanterns to illuminate the role that judges should play in keeping society open and strengthening democracy. So it was really greeted with open arms and with a sense that it was really needed and wise. And the fact that 59 years later, two justices of the Supreme Court are questioning it, when it's worked relatively well. I mean, it creates a balance, albeit a difficult balance for plaintiffs, between the two interests we're talking about, which is the First Amendment interest in information being distributed out to the public, and the contrary interest in an individual's reputation, which is an important interest as well. And it creates a tough test. And I thought I would start out really by the result of Sullivan, because we bandy about the term actual malice, but I think it's important to understand what actual malice really means. What it means is not what it sounds like, nor is it what the subtitle of actual malice is, which is knowledge of falsity or reckless disregard, as Rod said, to the truth. And recklessness is synonymous to negligence, and negligence is exactly what the actual test is not. So the Supreme Court's first words on this were very, very confusing, and still confuses both judges and juries alike. What actual malice requires of a plaintiff is to show that the publisher, the author, at the time of his article or piece, had serious doubts of the truth, that he had a conscious awareness of probable falsity. So it is a subjective test. It is hard to prove, but that's for good reason. And the reason why it should be a hard test is exemplified by the very facts of the Sullivan case. And I think it's worth spending a couple of minutes discussing that. So Sullivan occurred in the early 1960s in the midst of the civil rights movement in the South. And it was an ad placed by the civil rights leaders, including, this is the way it looked. There was an ad in the Times called, well, as you can see here, it's Heed Their Rising Voices. And it was an ad in the Times placed by the civil rights movement that essentially depicted the police force of Montgomery, Alabama, as doing very, very nasty and abusive acts towards the civil rights workers and the blacks in Montgomery. Strangely, and it didn't matter for the case, Sullivan was not named, even though he was the plaintiff. Sullivan was the police chief of Montgomery, and he felt that he was libeled by this attack, which did include some falsities. There's no dispute as to that. The falsities weren't huge in terms of what the police did that was so wrong, but they made it worse than the true facts were. That's true. But this thing that's important to understand is, why did Sullivan sue? His reputation wasn't harmed. In fact, among the segregationist establishment of the South, if anything, it was heightened because they were on the side of beating up the blacks and the civil rights workers. Nor was it an attempt for him to get money. That wasn't the reason he sued. He sued for the simple reason to try to kick the Times and the northern media out of Alabama so that they wouldn't report on the abuses that the establishment in Alabama were harboring on the civil rights workers. Because if those abuses weren't reported on nationally, they could continue behind the wall of silence and nothing would happen. Whereas if the country learned of what was going on the 6:30 news at the time, or in the New York Times or in Time magazine, then pressure would be brought on them to stop that abuse and change their behavior. And they didn't want any part of that. So it was really an attempt to shut up and shut down the northern media, and in this case, particularly the New York Times, probably the main victim, from even reporting. And they wanted them out. And if they didn't get out, they were going to have to pay lots of money in these sorts of libel damages. In fact, there were 8 other cases at the time, which totaled, I think, $4 million in potential liability, all of which would have changed the Times year from being profitable to being negative. So that was the strategy. And that when it came to the Supreme Court, after the jury and the Alabama appellate courts affirmed the verdict, which after all was probably a legitimate verdict and a legitimate view on appeal, given what the law was then, which was essentially strict liability. You said something false, you lose, as long as it created some damage. I mean, that's a very harsh rule for the media or for the speaker, that an innocent mistake can lead to overwhelming liability, not to mention all the legal fees, even if somehow you could win such a case. So that's what this case really is about. It's about whether to incentivize speech, particularly about public issues, or to decentivize it by scaring people into feeling that if they made even the slightest innocent mistake, they would be having to employ lawyers. And basically, if you're a small newspaper, you're not going to survive long that way. So that's what the case was all about. It went to the Supreme Court, as I say, after being affirmed in the Alabama appellate courts. And the Supreme Court decided that the First Amendment should have some say here and essentially constitutionalize libel law. Now, there are many exceptions to free speech, including false speech, including obscenity, including fighting words. So this is not the only carve-out. But the Supreme Court decided that the very meaning of the First Amendment suggests that the public has a responsibility to monitor and to decide whether to keep governors in or out. And how can they do that without full information about what government is up to? And you won't have that full information if you have a test that disincentivizes articles and distribution of information about those people. They also looked at the Sedition Act. The Sedition Act said that basically, like in England, you couldn't say anything negative about the government. Then it was repealed because our forefathers, in their infinite wisdom, realized that this was insane. We had created a revolution to get away from the fact that the monarchy was king and untouchable. And so in this country, that wasn't going to work because this was a government of the people, by the people, and for the people. So the notion that the Sedition Act was repealed makes total sense. And that was another rationale for the decision in Sullivan. You know, Rod mentioned that the reliance on the common law before the First Amendment in 1791, which is essentially the British common law. Now, why should our legal system depend very much on UK English common law before 1791, when again, that was the law we were revolting from? It's insane to think that that should be that we should be emulating that of all things. So Justice Thomas writes about that a lot. And to me, it makes no sense whatsoever. Or else why did we fight the revolution if we're just going to copy what was going on in England, which is the very reason we did separate from the British? So that's really what Sullivan's about. And as I say, it's really a matter of incentives. In other words, the Supreme Court really realized that we should have incentives for this sort of discussion and distribution of information, not the opposite. And what Justice Brennan wrote in his opinion, which I think spells it out in really one sentence, is that speech that falls outside of the First Amendment's protection must stop at the calculated falsehood. In other words, that shouldn't be protected. Put differently, if the definition of unprotected libel were expanded to include innocent misstatements about public officials, and now I'm quoting Justice Brennan, would-be critics of official conduct may be deterred from voicing their criticism, even though it is believed to be true and even though it is in fact true, because of doubt whether it can be proved in court or the fear of the expense of having to do so. They would tend to make only statements which steer far wider of the unlawful zone. And so that's how Sullivan came to be. That's why Sullivan makes sense. And I would just give one example that kind of shows why this is true. Let's say you're the publisher of a small newspaper in a small town. And let's say that your reporters have gotten evidence from reliable sources that there's corruption on the city council. And they've gotten lots of documents and they've gotten lots of testimony from sources, but they haven't gotten like the last smoking gun document. So while they're 99% sure they have it right, they don't have the final clincher. So the question is, should that story be written or not? They're sure that they're right. They're confident that they're right. They've done the work. It would seem to me that our country is based on the fact that there ought to be distribution of an article monitoring and bringing to light abuses on the part of government, even if you don't have the last percent of sureness in the story. And that's what Sullivan does. It says, well, these people didn't have serious doubts, so they should be protected. They certainly are not making it up. There's certainly not calculated falsehoods here. So that we ought to incentivize that story. But yet, before Sullivan, without Sullivan, where there was a strict liability regime, a publisher would say, I can't bear that risk because maybe somehow it's wrong, then I'm going to lose the case, not to mention the legal expenses. And I might have to fold up my paper. It's just not worth it to me. So the question is, which of those two regimes do we want? And I would submit, and it even is true with respect to non-governmental figures, which Rod talked about. But I would submit that if a similar article was written about Elon Musk or about a doctor who wrote a noteworthy article about how to cure COVID or what to do about COVID, or even whether the guy in the game, which I think I mentioned, in the Super Bowl, who committed the penalty that turned the game around, if he met with a gambler the day before the Super Bowl, wouldn't that be worth saying, even if we weren't, again, 100%, but only 99% sure? Wouldn't you want that story to be written about those public figures? Because those are all public matters. Elon Musk, a business leader, a famous entertainer, a doctor writing about COVID, all those things, it seems to me, ought to have the same burden, the same incentives that we're talking about, which is that you want those articles to be written rather than you want them self-censored. And it seems to me that's really what remains true today and what was true in 1964, when I think 59 years next week, the Sullivan case was decided. So I think I'll stop there. I hope I've given kind of a summary of why we are where we are and why I think it makes total sense and why I find that some of the attacks on Sullivan are so strange. But I'm sure we'll be able to talk more about that in the Q&A session with Judge Griffith. Thank you very much.
Thank you, George Freeman, and thank you, Rodney Smolla. As both have mentioned, there were technical difficulties in taping the original portion of this program on February 13th, so they were both kind enough to retape their opening statements for us. Now we will join the video of the debate at the point where Judge Tom Griffith poses a question to Mr. Freeman regarding alternative standards for the New York Times.
Offer you the outcome that you achieved in New York Times versus Sullivan, but a different standard. What do you take him up on that?
Yes and no.
Okay, how so?
I think, well, first of all, I totally agree with him that the word reckless disregard kind of screws everything up. People don't understand it, and it gives the wrong signal of what we're talking about, what the Supreme Court meant. And they clarified it later, but I have to give you, since you asked, one anecdote. We had a federal trial in Cleveland brought by a Supreme Court judge of Ohio. He didn't ask for a correction. He didn't communicate with the Times. He just sued us about a last paragraph in a story that actually had to do with the Sam Shepard case of 40 years earlier. In any event, the case went to the jury. It was a public figure case, but it somehow got by the actual malice test on the summary judgment motion. And the judge gave the jury instruction of actual malice and reckless disregard for the truth. And within the first few hours, the jury came back with a note saying, "We don't understand that. Can you clarify?" And I went to the judge and said, "Judge, you got to give them the sub-definitions that the Supreme Court came to in the next couple of years, which is serious doubts for the truth or a conscious awareness of probable falsity." And he looked at the Ohio jury book and said, "No, it's not the standard instruction. I'm not doing it." And 2 hours later, the jury came back again with the same request. "We don't understand this." And again, I begged the judge. And again, he said, "No, this is short and sweet is good. This is what the Ohio standard instructions are." And that happened the third time. The fourth time he came back, the jury came back, it was 5 o'clock on Memorial Day weekend, Friday night. And no one wanted this thing to go on into the next week. So finally, the judge gave the instruction that I've been asking for that explained what actual malice actually means in plain English. And 10 minutes later, the jury came back with a verdict in our favor. So it really is important to understand, as Rod just did, that it means a subjective awareness of probable falsity. It's not just extreme recklessness. And I think that's a good place to be. And I think that's consistent with really the law going way back into the early days of our country, where basically they use the term good faith. But good faith, again, like intent in criminal law, depends on a subjective interpretation of what is the journalist, what was the criminal thinking at the time. And the fact that that's part of this test, I think, is utterly reasonable and consistent with what the law was way back in our founding.
Well, then you've raised the matter of history, Mr. Freeman, and let me ask you, we have a Supreme Court that seems dedicated to using history, whether they call it originalism or history and tradition. Mr. Freeman, can New York Times v. Sullivan survive an originalist approach? Yes,
the answer is yes. It's consistent, in my view, with the vision and the purpose and the intent of the founders. It's interesting that Justice Thomas cites Blackstone quite a lot in his analysis. Yet Blackstone was a devoted monarchist who voted for the Stamp Act and really didn't think much of the colonists at all. So the fact that when I was a first-year law student, I had to understand Blackstone in contracts or whatever, I didn't realize that he really didn't stand for the principles that our founding fathers stood for. So I think a lot of the reliance on his doctrine, on his theory, is misplaced. And after all, the fact is we revolted from the British, okay? We didn't come here to then adopt all of their laws. The purpose of the revolution, the purpose of our freedoms, the purpose of our new form of government was to have more rights for the individual. That's what the Bill of Rights, freedom of religion, as well as freedom of speech and press is all about. So the notion that we should go back to British common law and just substitute that as our law doesn't make sense, because or else what was the purpose of the revolution? And in fact, that's what Jefferson and others said at the time, that again, that if you speak in good faith about public leaders, that should be defended. And that's actually what court rulings in the early 1800s said as well. So I think that Justice Thomas's originalist research takes the parts he likes and seems to ignore what I think is the weightier evidence that goes the other way, that shows that, for example, the founding fathers believed that the public leaders were assuming the risk of having discussion about them and had to take that list. Not the British approach was that libel was even more heinous when said about public officials. We believe the opposite, and for good reason. And so to rely on British common law for that really makes little sense.
President Smolla, my guess is you have a response.
Yeah, I do. I think that, of course, it's the case that the framers had a more robust conception of critique of government and freedom of speech than King George and the British tradition. So George's point is well taken there. And I think, notwithstanding the fact that the Alien and Sedition Acts were passed by that same generation, that Justice Brennan is right, that the judgment of history is against those acts. And there were many critics of the acts at the time, people like Thomas Jefferson, we think probably even John Marshall, though he never had to rule on the issue. But to say that they believed that you should be able to criticize government is not to say that you should be able to make a false defamatory statement of fact injurious to a particular government official, or that any particular standard should apply to that. And criticism of government is not necessarily the same as a false statement of fact about an individual. And I think as to there, it has to be the case that the framers didn't think they were changing things. It would be hard to explain how we went until 1964 with the wrong standard, if that were the case. But as you may have gotten from my opening remarks, I'm not saying history is the clincher, but I do think it forces George to justify it on policy grounds, which he's done and made that argument. I don't think he wins as a matter of history. That was interesting. You had almost the Freudian slip, Your Honor, of saying Roe v. Wade at first. But there is clearly a link in the jurisprudence. I mean, we do have people like Justice Thomas who look like they would be willing to move most of our constitutional law to the conceptions of those who enacted the original text. And so I don't think it's any accident, because I think his views and the views of the court in the Dobbs case echo what you've heard Justice Thomas say in his dissents in the New York Times cases.
Great. This question for you, Mr. Freeman. How do you respond to Justice Gorsuch's point that the media ecosystem of today is so radically different from the time of the New York Times versus Sullivan was handed down, so that the status quo today actually impedes the democratic function the court sought to protect in New York Times v. Sullivan?
Well, the ecosystem is different for sure. I mean, there's social media, which is the biggest difference, and there's more cable TV with more outlets, which are different, and they are taking more extreme positions probably, which is different. But in the end, you know, most of the news, most of the important information that we get doesn't come from people's tweets and individuals' posts on Facebook. It comes from the major media outlets. So in that sense, it hasn't changed that much. Justice Gorsuch's, I think, main criticism, you know, he uses the word ecosystem, is about how newsrooms now work. And he alleges that they work very differently than in the past. And with that, I would entirely disagree with him. And were he here, I would ask him if he spent any time in newsrooms. And I doubt, based on what he's written, that he has. First of all, he says, for example, because of cost cutting and because of reliance on Sullivan, that ignorance is bliss, there's less fact checking than ever. That's simply not true. When I started at the Times in 1981, there was no fact checking other in the magazine, other than the fact checking that the reporter himself or herself was making on the story he or her was working on. There was not a bank of fact checkers, as he postulates, which now doesn't exist. Basically, in the 1970s, it was only magazines that have fact checkers. And still today, magazines like the New Yorker have fact checkers, but no other media that I know of has a bank of fact checkers that he assumes. The bigger mistake he makes, and I'll be short, but the bigger mistake he makes, which is just an overwhelming mistake, is that the reporters are putting their heads in the sand because of the strategic nature of Sullivan. That is to say, Sullivan says you have to have serious doubts. The less a reporter will know, the better, because then you won't have doubts. So you'll do less and less research to be safer. First of all, that's wrong as a matter of law, because if you don't do enough research, you're not going to win a motion early on actual malice or anything else, because you didn't do a good job, and judges will understand that. So even as a legal matter, the strategy shouldn't be and isn't to kind of bury your head in the sand and not do as much research as possible. Secondly, reporters are trained to get the story right. If they don't, they get beaten up by their editors, they get beaten up by their colleagues, and worse, they get beaten up by the readers who won't trust them anymore. So the notion that that the reporters don't mind if they make errors because they can always say, well, I didn't have serious doubts as to this story, is simply ludicrous. Reporters get depressed when they have to make a correction, when they make a mistake, because all their training goes to exactly the opposite, to get the story right and as right as possible, and do as much research at 3 in the morning or reading extra documents to make sure they get it right. And finally, I would just say that, I mean, I counseled not only the New York Times newsroom, but small newspapers around the country and small TV stations around the country. And not once in 35 years of doing that did I ever suggest to a reporter, nor did a reporter ever suggest to me, aren't we better off not doing more research, that ignorance is bliss, because then the plaintiff will never be able to prove that I had doubts. Not once did we ever say that, or did I hear anyone say that. The object of reporting is to get the story right. And that object overwhelms any legal kind of strategic ploy that Justice Gorsuch has suggested exists. It simply doesn't exist.
Great, thank you. President Smolla, do you have more sympathy for Justice Gorsuch's description of news gathering and reporting today?
Yeah, I mean, I think, Your Honor, when we say the ecosystem is different, I don't think really, at least for me, it's the claim that the New York Times is radically different or CBS News is radically different. It's that the entire world, the entire information world is radically different. And George has alluded to this. And there is a whole lot of defamation going on by millions of private actors, small actors, and so on. And the harm often is exponentially worse than it ever was. At the time of the Times case, most of us got most of our mass information through professional outlets, through newspapers, magazines, broadcasters, and so on. Today, it's all over the place. Now, what exactly do you make of that is a complicated question. It's actually the kind of question that is difficult for a court to take on. It invites more of some sort of thoughtful legislative balance than a judicial decision, which might be an argument for freeing legislatures up to make reforms, which could be reforms on substantive issues like moving to a negligence standard or to a gross negligence standard, which I think would be enormously valuable in restoring balance. But there are other things, and I know, Judge, you're going to get into some of these other things, things outside of New York Times v. Sullivan that impact the ecosystem, that give us alternative ways to try to both provide more remedies for individuals and organizations and businesses, and also do a better job of protecting the integrity of our discourse.
Okay, and I will get to that, but let me jump to the chat and ask a question from one of our audience members, and this will be directed to you, President Smolla. If New York Times v. Sullivan is overruled, how do we avoid a problem that the UK is currently facing? Concerns have been raised by various British journalists that deep-pocketed litigants of means, including Russian oligarchs, have been misusing the English legal system to intimidate investigative journalism by suing for libel. Libel cases are often too expensive for journalists to defend, no matter how great the public interest at issue and no matter how true the allegations at issue. If our law takes the position that the expensive libel litigation has chilling effects that threaten free speech, can we leave it to states to address the problem through anti-SLAPP suits, for example, and or procedural reforms implemented that will effectively prevent chilling effects from libel litigation or the threat of litigation? So if we overturn New York Times v. Sullivan, do we face the same problems that the United Kingdom is facing now?
So my response to the questioner is that we may have had this kind of David versus Goliath notion that somehow the institutional press here or around the world is the victim, and these very powerful, well-heeled plaintiffs are out to punish them for daring to impugn their reputations. But as often as not, the David and Goliath are reversed. And the person who sees their reputation damaged is not some wealthy person, not some person who can afford to hire lawyers by the hour, not a person who has much ulterior motive other than to try to have their name cleared. The questioner brings up anti-SLAPP laws. My friends from the University of Denver were the original coiners of that phrase, and they wrote the book that at the time I thought was a great idea, anti-SLAPP laws. I'm on the blurb of the back of the book by George Pring and Penelope Canham introducing that idea.
President, it may be helpful for some of our audience to know what an anti-SLAPP law is. So if you could briefly just define.
This is a statutory innovation, and the idea is to prevent well-heeled litigants from bringing claims often for defamation, but they can be other sorts of claims, not because they really want to win, but because they want to chill expression and punish their opponents. Really, New York Times v. Sullivan was a SLAPP case, and SLAPP stands for the acronym Strategic Lawsuits Against Participation. But in my view, and some 30 states have now enacted that legislation. California was one of the leaders. New York just adopted a much more robust anti-SLAPP law that makes it, which is very important because it's such a center of American litigation and media reporting. But I think actually anti-SLAPP laws have hurt our societal discourse, because among the prime invokers of the laws now are very well-heeled media outlets who intimidate often private persons from bringing the cases, because the way most anti-SLAPP laws work in most states is that if you lose a motion to dismiss the case, which is really easy to do in a defamation case, you pay the other side's attorney's fees. And so it's a tremendous chill on any resort to the courts to get what you think is the reputational recovery that you deserve. And I know you want to keep us on our answers short, Judge, so I'll stop there.
Okay. Mr. Freeman, what would you say to our questioner who is concerned that overturning New York Times v. Sullivan will lead to a situation that as she describes in the UK?
Well, I would agree with her, not surprisingly. But I would point out for the audience who might not be aware that we being the Congress, actually dealt with this choice not very long ago. I think 10, 15 years ago, there was a case against an American author named Ehrenfeld, who basically claimed that a Saudi billionaire was financing terrorism. And he sued in London because it's easier to win there, and she was in the US. And she was advised by her lawyers not to even show up in London, because under British law, she didn't have a chance to win because she had relied on other people, and that wouldn't have been enough to prove the truth, which is what the burden is on the defendant in the UK. And so she had a default judgment that then the plaintiff moved to enforce in the US, where she had assets. Now, typically that's rubber stamped, but in this case, the judge felt that it was heinous to basically enforce this British law that so disagreed with our law, so inconsistent. And following that, the Congress got into the act, and in something called the Speech Act, the House of Representatives and the US Senate both unanimously voted to enact the Speech Act, which basically says that if a foreign country doesn't have libel law, which is consistent with ours, which means is consistent with Sullivan, then that judgment shouldn't be enforced, which is really rare because of principles of international comity and the like. So that just shows how British law is so far afield from our values and culture that the US Congress unanimously was willing to go so far as to really turn comedy among nations upside down, that it just to me underscores the differences and the danger in British libel law. And indeed, since then, the Brits have somewhat moderated their views and brought it closer to Sullivan, although not all the way.
Concerns about the corrosive effect of disinformation on our public debate informs some of the sense that New York Times v. Sullivan isn't working as it should. For both of you, and we'll start with President Smolla, are there alternatives to addressing the problem of disinformation short of moving away from New York Times v. Sullivan?
I think the biggest one would be modifying Section 230 of the Communications Decency Act, which is a federal statute that federal courts have interpreted as providing essentially unlimited, essentially absolute immunity for internet service providers for the defamation posted by another person. So Twitter can't be sued for something that somebody tweets, and Facebook can't be sued for something that somebody posts. That's a reversal of the traditional common law position. And that itself invites massive defamation and a lack of accountability. We don't do that on the internet when it comes to, for example, intellectual property. There comes a point at which the internet service provider notified that there's a copyright violation has to take action to take it down. Now, copyright's easier because it's easier typically to tell whether there's a copyright violation as opposed to defamation. But that would be, I'll just end there, Your Honor. I think some adjustment to Section 230 would be a very positive step. I think that the way it's been interpreted is not what Congress originally had in mind, but it will probably take some action by Congress to bring it back within the compass that I think it originally envisioned, although the Supreme Court's being invited to do that. But that's one exemplar of something outside of what we're debating tonight that would, in my view, have some positive impact on our discourse.
Mr. Freeman, are there alternative ways to get at disinformation short of overturning New York Times v. Sullivan?
Well, I think I have two answers for that, two different answers. One, really dealing with what Rod said, is not to really disagree with him very much, but just to say that changing New York Times v. Sullivan and trying to cure the problems of disinformation are really apples and oranges, because disinformation, as much as we dislike it and find it troublesome, is generally 95% of the time not liable. If some idiot puts on the internet that chloroxine is a cure to COVID, or that 9/11 or the Newton kids massacre didn't happen, or that there was election fraud in 2020, none of those statements libel anyone, because a libel has to be about a person or entity and ruin their reputation. Those are just very troubling, dangerous, false facts, but they're not about a person that would yield a libel suit. So therefore, changing Sullivan or not changing Sullivan really has nothing to do with the serious problem that does exist with disinformation. And I think Rod is right that problem has to be dealt with somehow in the context of Section 230. But I don't see 230 being changed simply because Congress doesn't agree on anything these days. It's a political issue because each side says the other side is letting disinformation on its platforms. And so no one really agrees. I think the answer is in greater content moderation and greater responsibility by the platforms themselves. And they have the problem, and I think a legitimate problem, there's just so much material. How can they really review every post that goes on Facebook or Twitter? It's just the volume is overwhelming. And I understand that, and we've come a long way. 10 years ago, I spoke up at an industry meeting and said that the big social media platforms ought to be doing more in censoring stuff that is patently wrong and dangerous. And I was met with total silence. And since then, that has happened. Now, many would say more of it should happen, although many people think that too much censoring is happening. But the one thing I would say, just to conclude that part of my answer, is that government shouldn't be the censor, because that's the greatest danger of all. And that's something our system has staked itself not to allow, that government will end up being the arbiter of what should be disseminated and what shouldn't. So that's, I guess, my answer on the question you asked.
Thank you. So I'm going to ask one more question, and then we're going to give both of you time for a short closing statement. But my final question for you is to put on your caps as prognosticators and predictors. What do you think the Supreme Court is likely to do with New York Times v. Sullivan? Why don't we go with President Smolla first, and then Mr. Freeman, your predictions?
Well, Your Honor, let's just lay out the pros and cons of trying to be predictors. On the side that it was going to do nothing, so on the argument it's just never going to take a case, there's the fact that it had to cert petitions with fairly high visibility. The Bill Cosby case and the Barisha versus Lawson case, and you never got more than 2 votes, at least as far as we know. We certainly didn't get 4, the court would have taken the case. So that's not a good sign for those who want the court to do something, to think that it would. I authored the petition for certiorari in the case that came from your court, in the Ta versus Global Witness case, and said we weren't trying to get New York Times v. Sullivan overruled. We were just looking for some of these more incremental adjustments. And that didn't get anywhere. I pointed out to the court in that petition that not a single current sitting Supreme Court justice has ever been on a First Amendment defamation case. They've cited the cases, they obliquely dealt with the case in a case involving the FAA. But all those famous line of cases in the aftermath of New York Times and Gertz were on this older generation of justices. None of these justices have ever said much about it. So I think that there's a possibility, not so much in the near term, but in the longer term, and I'll end with this, that if the perfect case was put before the court might be willing to take it. And for me, the invitation would probably be not a public official case, but a non-governmental public figure case in which there was no question the story was horribly flawed and wrong, no question the plaintiff had been damaged, no question there was negligence, yet still the plaintiff loses for want of actual malice. That's a very sympathetic case. If you had that perfect storm, maybe there'd be enough justices to at least say, we'll grant cert and take a look at this.
Mr. Freeman, what's your prediction?
My prediction is that nothing's going to change. I mean, Sullivan has been the law for 59 years as of 2 weeks from now. It got at most 2 votes, and Justice Gorsuch was more questioning than anything else, whatever that means. There was such a case, I think, that Rod just enumerated in the Southern Christian Leadership Union case, which was a public figure case, not a public official case. And that didn't seem to get any more resonance in terms of reviewing the actual malice test than any of the others. And I also think the Supreme Court is being so kind of criticized for and under a cloud for in public perception for changing some of these super precedents, that in this area, which maybe doesn't interest them that much, and where there is kind of agreement, and they'd have to overturn a lot of Supreme Court precedent if Times v. Sullivan went away, a lot of other Supreme Court cases which were based on it. I don't really see it happening. I would just say as a last word that if they play with it, or if they do something with it, what I would like to, I think, see, or at least I don't understand why it hasn't gotten more currency, is a return to the Rosenblum standard. In Rosenblum, the Supreme Court, which came after Sullivan, the Supreme Court left the actual malice standard, left the categorization by either public figure or private figure, and said actual malice applies if the matter is of legitimate public concern. And to me, that kind of better mirrors maybe what the framers had in mind in terms of an incentive for important stories we should know about, and not that same incentive for stories that really deal with just private matters that people shouldn't be terribly concerned about. I'm not sure why that Supreme Court basically retreated from that after a year. What I gather is that they felt uncomfortable deciding what's important and what's not, but they have the same amount of trouble deciding who's a public figure and who's not. And I just think that if Sullivan is tampered with, which I don't see happening, that might be the most likely change. And whether that's good or bad for the plaintiff side or the defense side is unclear. It would change the balance a little bit in different cases, but it would depend upon the facts. I think otherwise it would lead to kind of the same balance, but just a different lineup.
Great, thank you. Well, thank you very much. Well, we'll now give each of you a minute or two for a closing statement, and we'll start with President Smolla, and then Mr. Freeman, you'll get the final word. President Smolla.
Thank you, Your Honor. You know, one of the nice things about arguing in your former court is that you really didn't keep time. Not unlike a lot of courts that I'm in, but I'll try to stick within a minute. George mentioned this recent case, which is the Coral Ridge case, and it prompts me to add one other thing to my perfect case, and that is no other defense would be in play. One of the problems in the Coral Ridge case is that it was really an opinion. It really wasn't a factual statement. So a clean case would be no fair report issue, no opinion issue. It's up or down on actual malice. I'll end with this. I think that George's suggestion that the better move is to expand the actual malice standard and go back to Rosenblum is an echo of another theme that some have argued, which is that we should adopt what the Second Circuit invented in the Edwards versus Audubon case, the neutral report privilege, which some argue, I'm involved in a big case now in which this is being argued, essentially gives protection to anything that is newsworthy. And I just think that that's moving in exactly the wrong direction, the opposite direction. The press has enormous protection already, and all citizens have enormous protection already under the actual malice standard. To go beyond that is really piling on. I don't see the Supreme Court doing that ever, and I think it would be a terrible idea. But thank you, Judge, for your wonderful questions and moderation. And George, it's been a pleasure to see you and be with you again.
Well, we finally come to something that it seems like, really disagree with on the last point that Rod made. And I feel somewhat abashed because I got to say, he's the dean of the Vermont Law School. And in 1973, I was the first assistant dean as a 1L in law school. I became an assistant dean at the new, just then founded Vermont Law School. So I somehow feel abashed since he has this higher position. Although I was there, 40 some years earlier as a law student, I was a dean of the law school, which is hard to imagine, but interesting. In any event, I think neutral reportage is vital. And I think the current election machine cases give a great opportunity for that doctrine to be founded, because it requires, and Rod didn't mention this, it requires a defense that something you repeat someone else saying is newsworthy, such as the President of the United States, but only where the original speaker is responsible and where you report it neutrally, objectively, and you don't endorse it or favor it. And it seems to me that is a good balance between a news media's responsibility to report what important people are saying, but not do so in a way that is prejudicial, either because the speaker is irresponsible or because you're endorsing that point of view rather than just reporting it. The last word I would say, Judge, is, this whole dispute has kind of come to the forefront because of Justice Gorsuch and his opinion, which really talks about some statistics that show that actual malice and libel suits are a dead letter, I think is the wording he uses. And that's simply empirically not true. There have been more lawsuits in the last 5 years than in the 20 years before that. Those suits have had probably more plaintiff, or at least equal successes for plaintiff. There are less trials, but that's because there are less trials throughout the civil docket, not only a libel case, but all other cases, because cases are settled. And finally, when motions to dismiss or summary judgment motion are granted the defendant, the media, that is because in, I think, 85% of the cases, the dismissal comes because of, as Rod mentioned, opinion, fair comment, the fact that there's no defamatory meeting, not because of Times v. Sullivan and actual malice. So the notion that this is the cause is simply ill put. And let me just read one sentence of a report in the 1980s that said that America is in the midst of rejuvenation of the law of libel. Only a decade ago, defamation appeared to be headed for obsolescence. Yet an astonishingly shift in cultural and legal conditions has caused a dramatic proliferation, by the way, like we have today, of highly publicized libel actions brought by well-known figures who seek and often receive staggering sums of money. And that was written by Rod Smolla in an article in the early 80s at the time of the Westmoreland and Sharon cases. But the cases by former President Trump and Congressman Nunes are very similar to that streak of cases back then. And none of that can be attributed to Sullivan. Sullivan had been ruled on 20 years earlier. So why do we think that the up or down in the number of cases deal with a 59-year-old precedent, either the rise in the 80s, the fall in libel cases in the aughts, and now the rise in the last 5 years? Sullivan really has not affected any of that.
Great. Well, thank you very much. And thank to both of our debaters today for their erudition and for their clarity. And might I also add, and it's only fitting that this happens at Catholic University, for your collegiality and kindness to one another. We've all had demonstrated a virtue that's sorely lacking in much of American discourse today. Two well-educated patriots who care deeply about an issue, see things differently, and yet are able to discuss it with one another with respect and may I dare say even affection. So thank you very much for demonstrating that. And I'll now turn the time back to Professor Harmon.
Thank you very much, Judge Griffith, and thank you to President Rodney Smolla, George Freeman, and of course, Judge Tom Griffith, our sponsor, the American Enterprise Institute, and our student organizations for another thought-provoking and engaging evening. Please return next year for our 2024 installment of the Seigenthaler debates here at Catholic University's Columbus School of Law. On behalf of Professor Brigger and myself, A.G. Harmon, thank you all and good night.